right, and a slight change to the program, but we're lucky now again to have an international speaker. Professor Bibi Sangha is a professor at Flinders University and has a relatively glamorous background, admitted to the bar in the UK and Australia and Malaysia as well. Studied at many places, including the London School of Economics and I think the University in Canberra at ACT, Australian National University. But she's going to present to us today on the new right of appeal to get some of the cases back to the courts. The floor is yours. Thank you.
Okay, what I propose to do is probably keep my session a bit shorter so that Bob will get an opportunity to speak about some of the cases that we have been dealing with, and then both of us can take any questions at the end of it so that it flows faster. May I start by first of all congratulating the organizers of this meeting for having the insight to bring together international perspectives on wrongful convictions. There's much we can learn from each other, and I've certainly learned a lot from Bruce MacFarlane's talk today. When we ask the question, what can be done about wrongful convictions, we would have to commence by saying that the Australian position, generally speaking, has much in common with those of other similar countries such as New Zealand, Canada, the United Kingdom, etc. I will look at the procedural issues, the process by which one might seek to take one's case back to the courts. After all, when somebody is convicted, they're convicted by a court of law, and in Australia, it's constitutionally recognized that it is the court of law that can quash that conviction. So that this system of seeking mercy from the executive, it's simply that. It's simply seeking pardon from the punishment, not from the offense. So I will look at the procedural issues, and then Bob will look at the cases that we have worked upon. Until recently, the procedural problems were common across all Australian states and territories. In Australia, criminal law is within the confines of state jurisdiction, unless it's a federal offence like drug trafficking, terrorism, etc. Then the federal Attorney General takes over. Otherwise, you're prosecuted for murder, and other serious offences by the state in which that offence had occurred. Most ordinary people are surprised to learn that in Australia, once a person has been convicted of a serious crime and has had an unsuccessful appeal, they do not have any further legal right to any hearing of their case, no matter how compelling that evidence may be that they have been wrongly convicted. Say, for example, if the state had presented false or misleading evidence at the trial, and then later, years down the track, that comes to light after the initial unsuccessful appeal, it can still deny the person further access to the courts. What I've attempted to do is to put it in lay terms, because I was conscious that we'll have non-lawyers amongst us. It essentially works like this. After an unsuccessful appeal, the appeal court will say it cannot reopen the appeal or hear a second appeal. And the explanation given in cases is that we, the judges, look carefully at the wording of the relevant legislation, and we must then act strictly in accordance with its meaning. They will say that there are no rights other than the rights granted by the legislation. But there's a problem with this. The relevant acts in each of the states in Australia do not say there's a right to only one appeal. What they say is a person may appeal, and then it goes on to set the grounds upon which the appeal may take place. The numerical limitation on appeal is not a product of the wording of the legislation, but of the judge's self-imposed limitation. They want there to be some form of finality in litigation. They most often justify this by pointing to the petition procedure. They will say, look, you have got an effective remedy for exceptionally deserving cases by petitioning the Attorney General or the Governor. But as we will see, this does not necessarily work. So after being shown the door by the State Appeal Court, a person claiming to be wrongly convicted may well approach the High Court, which is Australia's Supreme Court, with the expectation that probably this is the court that will fix things. But that too may prove to be a severe disappointment. If the applicant wishes to produce some fresh evidence to demonstrate that the state may have behaved badly in securing the wrongful conviction, the High Court will tell the applicant, sorry, we can't hear it. The explanation will sound very technical, but it will effectively refer to some fundamental constitutional principles about federal and state powers in Australia, how the High Court, in its exercise of federal jurisdiction, cannot exercise state powers, and the hearing of any admission of evidence is a matter of original jurisdiction, which means only a state court can hear that. But Bob and I have taken the view that the High Court does have a power to remit matters to a lower court to exercise powers on its behalf. There's no reason in principle why the High Court cannot remit the matter to the State Appeal Court to admit that evidence, to admit that fresh evidence, and then say the matter now be remitted back to the High Court for further procedure. Although it technically exists there, we haven't come across in practice any cases where that has been done. So assuming that a deserving case is shown the door by the High Court, there's one further glimmer of hope, and that is called the petition procedure. This is often and understandably confused with the procedure called petition for mercy, and equally often confused with the exercise of the power of the state governor. A wrongful conviction petition is in fact an application to the Attorney General to exercise a statutory power to refer the matter back to the appeal court to be heard as an appeal. However, experience show very clearly that even the most meritorious cases will often not be referred to the court. There has been a Court of Appeal case, and fairly influential Court of Appeal case in South Australia on this issue, which says, now this would be surprising for some lawyers here, it says that an Attorney General has an unfettered discretion in relation to the exercise of this power, and the attorney can refuse a petition for any reason or for no reason at all. It is said that an applicant has got no legal rights, it having been assumed that all legal rights have been exhausted, and that this power exists in some region beyond the scope of rights and duties. It's a very strange thing for a right which is actually set out in legislation. Reasons do not have to be given for the rejection of a petition, and there will be no right to judicial review of any decision to refuse a petition. And that's unlike the position in both Canada and the United Kingdom, where reasons have to be given. We had gone through this procedure in South Australia in relation to several cases, and in every case, the petition was refused. In one case, we had met so many extensive written submissions that it took the Solicitor General, who was advising the Attorney General, 4 years to answer that petition. We then determined, as academics, that this was far from satisfactory, that common sense, ethics, and the integrity of the legal system demanded that something be done about this. So in 2010, with our co-author, a Canadian professor, Professor Christchurch from University of Toronto, we wrote a book, Forensic Investigations, in which we recommended that Australia should follow the lead of United Kingdom and establish a Criminal Cases Review Commission. And rather like the one currently in the New Zealand Parliament. The UK Commission, which had been working for some 13 years by 2010, had already referred some 300 cases where the convictions were overturned. And I just checked the figure today, or rather since the end of August, it's over 440 convictions. So with the help of a Member of Parliament, both Bob and I helped to draft and introduce a bill to the South Australian Parliament to establish a Criminal Cases Review Commission. We could only do it in South Australia because, again, criminal law being the purview of the state meant that at that stage we could only lobby the South Australian Parliament. In the months leading up to that, we had also put in submissions to the Australian Human Rights Commission. We had argued that the appeal systems in all states and territories in Australia had failed to protect the right to a fair trial and the right to an effective appeal. So in other words, if significant evidence has come to light showing that this conviction was wrongful, then you haven't had a fair trial and you are now denied an effective appeal. There were rights which were guaranteed by the International Covenant on Civil and Political Rights, and which Australia had signed up to in 1980, and they also, I understand, apply to New Zealand. As it happened, the Australian Human Rights Commission broadly agreed with our submission. In the meantime, the South Australian Parliament had referred the CCRC bill to a parliamentary committee, which then sought public submissions. The Human Rights Commission took the opportunity to put in a report to that committee stating, broadly as we had suggested, that the appeal system in all states and territories in Australia had failed to comply with its international human rights obligations. The committee took this seriously and recommended in its report that South Australia should adopt a new statutory right of appeal. So in other words, the right to second or and further appeals. It reasoned that a number of states, including South Australia, had enacted provisions to get round the double jeopardy provisions. This meant that where there was fresh and compelling evidence that showed that a person may be guilty of a serious crime for which they had been previously acquitted, then the prosecutor should be entitled to apply to the court for permission to lay further charges. The parliamentary committee reasoned that if there could be a further prosecution where there was fresh and compelling evidence of guilt, then why shouldn't a convicted person have a further appeal where there was fresh and compelling evidence of wrongful conviction? And this was persuasive. The South Australian Parliament accepted this and enacted legislation, which came into force on the 5th of May 2013. The Legislative Review Committee had made two further recommendations which were not taken up. One was that it had recommended the establishment of an inquiry into the use of expert evidence in criminal trials. And the second was the establishment of forensic science review panel to enable the testing and retesting of forensic evidence and for appropriate cases to be referred to the appeal court. Over the last week, we have come to understand that the Victorian Attorney General says that she's going to take that on board as far as Victoria is concerned very seriously, and that she's going to bring it to the Attorney General's meeting of all the states and as well as the Federal Attorney General. But I think Bob will have the opportunity to discuss that further. Now, the other important point that I'd like to make is that when this new right to further or subsequent appeal came into effect, it was the first major change to criminal appeal rights in over 100 years. So that was quite an important milestone. At first we thought that there was a danger that a restrictive interpretation of the statutory provision would make this too demanding a test for many deserving cases to surmount. For example, where it could be shown that there had been some legal error at trial which would not on the face of it involve anything amounting to fresh evidence as defined by the legislation or even at common law, then such a case could be rejected at the leave to appeal stage. However, we were confident that the first of our test cases, that of Henry Keogh, would have plenty of fresh evidence to enable it to surmount the statutory test, and so it proved. His conviction for the murder of his fiancée by drowning her in a bath was overturned in December 2014 after he had served over 20 years in prison. We were able to establish that the forensic evidence supported that it was an accidental death and not a murder. A more difficult issue arose in the second case that went under this new appeal right. It was the case of Adrian Drummond, who had been convicted of the attempted abduction of a young girl whilst on her way to school. There had been forensic error at his trial. However, it was something which could have and should have been identified and dealt with at the time of his trial, if the defense and the prosecutor had picked it up. However, a majority of the judges on appeal reasoned that the expert witnesses and prosecutors had a duty not to mislead the court, that the defense and others were entitled to rely upon them acting in accordance with that duty. If it was subsequently discovered that their evidence or submissions had been misleading, then that discovery would satisfy the fresh evidence test. And it would almost certainly amount to something that is also compelling. So our initial concerns when the legislation was passed is the courts may take too restrictive view was allayed by this subsequent decision. So this greatly broadened the meaning to be attributed to the statutory language, and in a manner which we believe was in accordance with the intentions expressed by members of Parliament when speaking of these provisions. Following on from there, the Tasmanian parliamentarians had asked us to brief them on the operation of the South Australian Act, which we did. They subsequently enacted similar provision, which came into effect in November 2015. It should be noted that there wasn't a single dissenting voice or vote in either of the two parliaments in passing these provisions. The Attorneys General of both states said very clearly that the existing petition procedures had not been satisfactory because of the lack of openness and accountability in the process. They agreed that decisions of this nature should be dealt with by the open, accountable, and of course, appealable processes of the court. I should mention that there are some special procedures which operate in New South Wales and the Australian Capital Territory, which enable judicial inquiries to be initiated into possible wrongful convictions. However, initiating an inquiry is still very much a discretion, and the procedure itself is said to be administrative and not judicial, which could lead to potential complications of a constitutional nature. It's clear that such an inquiry could be long, complex, and certainly very expensive. Having said that, of course, we must acknowledge the 7 judicial inquiries in Canada have been especially valuable in helping us to understand the causes of wrongful convictions. That is especially so because of the international comparative exercise which each involves. It reinforces our view about the value of international collaboration. It is also reflective of the work of Bruce MacFarlane in his series of very valuable reports, which are important international and comparative studies of causes of wrongful convictions. However, the costs of such inquiries have to be carefully considered because Australian inquiries don't take that broad international focus that Canadian inquiries do. The recent case of David Eastman in Australia involved the assassination of a senior police officer nearly 30 years ago. His various appeals, the judicial inquiry that followed, and his subsequent unsuccessful retrial have cost around $30 million. Many would think that such a sum of money could have been used more effectively if it had been sent on an effective review commission. We are aware, of course, that the petition procedure in Canada has a number of features which make it significantly better than that which prevails in Australia. It is assessed by the Federal Attorney General, not the State Attorney General, and it's assessed according to the published criteria. Drafts and final reasons are given for decisions, and the decisions are judicially reviewable. The Attorney General in Canada can even set aside a wrongful conviction without referring it back to the court. We are also aware that the Review Commission that operates in UK, whilst far from being perfect, has enabled the overturning of over 440 convictions, which otherwise had exhausted all avenues of appeal. They included over 100 murder convictions and the convictions of 4 people who unfortunately had been hanged. The procedures which prevail in Australia are still, we would argue, deficient. Whilst 3 convictions have been overturned under the South Australian new appeal provision, the more recent decision of the Court of Appeal in the matter of Derek Bromley, an Indigenous man in South Australia, gives rise to some serious concerns. It's currently being prepared for leave to appeal to the High Court. However, we cannot understand the difficulties with that case without an understanding of the cases which preceded it. And that's a task I will leave to my co-researcher and my co-author, Bob Moles. So what I'll do is I'll leave it there, and then Bob could take over, and then at the end of it, we'll both be happy to answer any questions you have.